Okay, great. So good morning to you all again. We've got some people that are on screen. I know some other people are tucked away through the magic of Zoom. So thank you to everybody that has come along today. It's a real pleasure to meet you. My name is David Hudson, and I'm going to talk to you about employment law changes in April of 2023. Just to say, we are recording this, so we like to send this out to our clients that haven't been able to come along today, and we will also share after this the slides and a few other hopefully pieces of helpful information that will help with you getting ready for the employment law changes this year. So just by way of introduction, for those of you that I haven't met, my name is David Hudson. As I said, I am the proud owner and director of the HR department Clapham. You'll see in my picture, I'm joined by two superb colleagues, Kirsty, who's with us today, and Connor. And between us, we look after a range of businesses in the London area, particularly down in the west side. I have over 25 years experience in all sorts of areas, including operational management, leadership, organizational development, and have worked up to board level. And I am qualified with a master's, and I'm a fellow of the CIPD. And my whole reason for sharing this with you is that what we will want to do with you today is to provide very practical advice, not just on what the employment law changes are, but how you can implement them within your own organisations. So my plan during this next 45-50 minutes is to talk to you about what are the employment law changes that are coming in 2023, to talk a little bit about some of the key employment cases that have arisen in 2022, and mainly to have that, to go through those with you, because there's some really good learnings in there that we think, having looked at what's going on with some of our clients recently, and at the moment, there could be some good learnings there for you to take away. And then finally, at the end, to give you the opportunity to ask any questions that you might have. So as I said to you, the webinars are very interactive. I would ask you please to use the chat function if you have questions. We are going to leave time at the end of the session to answer those questions, and hopefully, if needs be after the session, be great to connect with you if you've got anything more specific to your business that you'd like to discuss. But the first thing I'd like you to do is just take to the chat function and give me a view on where you are at the moment in terms of the HR people piece in your organisation. Which one of these people risks are you most concerned about? So which of these are you most concerned about? And if you could pop your answers in the using the chat function, that would be super. So I'll give you a minute or so to do that. There's no right or wrong answer here, by the way. No shaming if you don't pick out the right thing or scrutiny. Just would be interested to hear what your view is. Yeah, absolutely, Leanne. Yeah, great. Yes, thank you. Yeah, and you're right that we certainly are seeing top of the agenda for many clients at the moment is the challenge of losing talent and being in a situation where they can't replace them. So we just have a couple of people joining us, so welcome to those. Welcome, thank you for joining us. So was just asking here, and feel free to go to the chat function if you can, to tell us what are the main people risks, what are the people risks that people are mainly concerned about. And just from the answers we've had, losing talent most definitely is up there. You will probably be finding that not only is the challenge losing the talent, but actually is recruiting talent to replace it. And to give you some sort of statistics, I know, for example, one client of mine is trying to find a finance director, and they've gone through something like 80 candidates and still haven't found the right person. I'm just going to pause for a moment because it's great that we've got some people coming through. So just pause for those good people to join us. Great. Welcome to all of you that have joined. You're very welcome. You're very welcome here. We've just started, so just to say that we're just talking about what the current challenges are that people are finding, and we were sharing our experiences on that. The other point that you raise, which again is very topical for us at the moment, is around the whole issue around health and well-being. So we are seeing a much higher incidence of short-term absence, for example, and within that, a lot more individuals seem to be very challenged with what's going on. So mental health, as I'm sure most of you will have expected, is an issue. You know, the cost of living crisis, the Ukraine situation, inflation, all of those things are unfortunately having quite an impact on people. So the reason that this is relevant is that some of what I'm going to share with you now does look to directly and also indirectly address some of these concerns that you've got. And hopefully when we get to the end of today, you'll have something you can take away that will help you maybe address some of those concerns. Also, as I said, happy to answer questions about any of this particular points at the end, or we are around and can have calls and everything else. I can come and see you if you want to talk about it. So without further ado, then let's look at what are the key changes. And as some of you may know, employment law has 2 points. So mostly on the 1st of April, but around the start of April and then in October, employment law changes come into effect. Typically in April, they will be the more statutory rates and other bigger ticket items. And then in October, they can sometimes be sweep ups for the smaller, maybe less impactful legislation. Hence why the 1st of April will be a key point for you if you're managing people or managing a business. And I'm going to talk through with you what those changes are now. Starting with the increase in the national minimum wage. So from April this year, the minimum wage increases, as you can see from the table in front of you. There is, I believe, a sense from the government that they wanted to maybe inflate it slightly higher from where it was before, just as a slight nod to the cost of inflation challenges that are taking place. The other big rate change that will be happening is within the family, what we call the family friendly arena. So this will be areas such as maternity, paternity, shared parental leave, bereavement, and that rate changes from what was £156.66 a day to £172.48. Sorry, not a day, a week. So slight increase there. You'll probably know if you've been looking after employees that are out on one of the family friendly leaves, so maternity, adoption, paternity, that even that rate itself is is challenging. But nonetheless, there is a slightly higher percentage increase in this year, as I said, in nods to the cost of living crisis. The other point is that sick pay goes up. So where it was £99.35, it's going to increase to £109.40. So the really important point here is that often we find that clients miss these changes and suddenly find halfway through the year that they are paying below minimum wage, which is obviously illegal. So your action here would be to go and check your policies and your contracts. And if you're employing hourly staff, making sure that that increase is applied as soon on or as soon after the 1st of April as you can, so that you remain compliant with that. There are, as you'd expect, more and more stories coming through the press where the consequence of that, beyond employees taking action in tribunal, for example, is that HMRC can severely punish employers. So that we're reading stories at the moment where HMRC are issuing £20,000 penalties for failure to pay the right level of pay to staff. So yeah, that's not a place as you would expect that you want to be in. The second big increase that you will want to be aware of is the increase in the statutory redundancy pay. And just incidentally, that this figure is also the figure that is linked to the way that unfair dismissal awards are worked out through what we call basic award calculation. But most importantly, statutory redundancy pay increases. You may be aware that statutory redundancy pay is worked out on what can sometimes be a little bit of a complicated formula that's based around an employee's weekly pay, their length of service, and their age. In reality, what that means ultimately is that there will be a maximum amount that an employee can claim for redundancy, and that has gone up to £19,290. And that is based on the increase in the maximum weekly pay amount of £643. So with redundancy pay, what I always recommend is that the government has a really good redundancy calculator on its .gov site, which is useful to use to calculate redundancy payments. You can talk to us, obviously, if you're unsure about how the formula works. But importantly, again, you must make sure that if you are dismissing an employee by reason of redundancy, that statutory redundancy payment is included on top of their notice payment. And you will want to check your contracts of employment to make sure that you're watertight around how you treat those. So that increase goes up to £643. I think it was just on, if memory serves, either about £570 to £590 last year. And what that does also mean, which is worth being aware, is that that in itself, as I said, increases the maximum unfair dismissal basic awards that could be awarded against you at a tribunal. And that award has gone up to £19,290. So, that's quite a lot of money if you are found to have dismissed an individual unfairly, and that's only the award itself. What we often tell clients is that if you are standing in the dock, you probably will have spent between £10,000 to £20,000 to be in that position. So not dismissing an employee in the right way could cost you anything up to £40,000 just as a start. So, always worth being aware of that. And if you are in HR or you're managing businesses, worth letting other people know, your managers know that can be the actual financial cost of the mistakes that they make. So the next thing I want to talk about is the coronation, which is something I think that is a small sort of shard of light in an otherwise difficult environment that we're in. Everyone that I talk to seems to be quite excited about the coronation. As you will be aware, on the 6th, Saturday the 6th of May, His Majesty the King is crowned, and it's going to be an amazing event, something that we don't see obviously often. And the Monday following that, Monday the 8th, has therefore been declared a bank holiday. Hurrah, everyone's super happy, and I think everyone's making plans to have street parties and long lay-ins and all sorts. Without kind of bursting that bubble, there is an implication for us as employers and within HR to think about how is that bank holiday treated in relation to the contractual agreement you have with staff. So it's worth noting that the new bank holiday is not automatically granted. So it's not the case that by virtue of the government's decision to create the bank holiday, everyone suddenly gets the day off. The determinant of how that bank holiday is treated comes through your employment contracts. So to give you a little bit of colour around that, if, for example, your contracts refer to a particular number of bank holidays, so I've seen some contracts will say you're entitled to 25 days and 8 bank holidays, then it would be reasonable to assume that the employee wouldn't be eligible for that bank holiday, because this bank holiday is bank holiday number 9, if you like. If though the contract states that employees are entitled to bank holidays without stipulating the number, then it's likely that that employee will be entitled to take that bank holiday as usual. So the answer here around how do we treat that is based on you looking at your contracts of employment and understanding how bank holidays are positioned within that contract. The other thing to think about is that in actual fact, beyond the contract, you may organisationally want to take a decision to allow for people to have that day off because of what it, what it obviously represents. The fact that probably a large majority of the rest of the country will also be off, but clearly there is a financial and potentially an operational impact on that. So obviously we can't, we can't forget that. Do also, if you're working in environments where there are the need for more hourly workers or shifts and Mondays is impacted on that, do make sure you're thinking about how to staff that. And also the contra to that, which is potentially you could get quite an influx of people asking for leave on that Monday, and you will want to think about how you then manage those requests too. So as exciting as it is, it does unfortunately bring a bit of complication. My advice here is just to go and look at your contracts now and start making your decisions about how you deal with the coronation. Again, just for the people that have joined us, do feel free, please, to drop into the chat function any questions you have, and I'll look to answer those towards the end of the session. Okay, with some trepidation, I'm going to move on and talk about holiday pay. Now, I know we have some HR colleagues with us, and I'm sure I speak for the majority when I say holiday pay is one of those nightmare areas that no one ever really wants to get into. You know, holiday pay has changed. The days of everyone has 20 days off a year, it's easily calculated, and part-timers have pro rata are gone. And moving into this area is unfortunately a situation that's becoming more and more complicated. And this case in particular is probably a good example of that. So by way of some background, the Harper Trust v. Brezel case, the individual, Mrs. Harper, was and is actually a music teacher in a school, and essentially challenged the school's calculation of her holidays based on the fact that she was working term time, and how that was then reflected in the numbers that they come up with a holiday. I'm not going to to turn this into an employment law masterclass, but to say it got particularly complicated. And the problem was that it was seen essentially to be by the tribunal a disparity between how the trust was calculating Mrs. Brezel's pay and what the working time directive says should happen. And that therefore got us to this point where the calculation of irregular hours was seen to be incorrect. So it's another probably whole half an hour for me to explain to you how that's worked. And certainly Kirsty and I are probably still getting our heads around it as well. So I appreciate it is a big area. I wanted to pull it out because it's important that you keep sight of the fact that where you've got workers that are irregular hours, 0 hours, and all of those permutations therein, that you have got a clear understanding of how to calculate their holiday pay, because obviously this is becoming more and more of a minefield. Albeit you may also know that there was quite some, vocal feedback, if you like, from Commerce and the small to medium-sized business community, and the government has committed to going back and undertaking a consultation around how to tackle what is actually seen as a disparity between what people may work and how the pay calculation is worked, because the two things are arguably slightly out of sync. So keep your eyes on that. We can advise on that, as I've said previously. You might need to give me a little bit of notice so that we can properly get into that for you, because it's not a favourite area, I think, of anyone. So yes, just to keep you updated on that. Okay, so those are the main changes that are going to be taking place. The decision, I think, to leave it at that is driven often, I think, by where the government is. The change agenda is probably being pushed a bit forward based on all the other things that we're trying to grapple with as a country at the moment. But nonetheless, there are some quite interesting potential changes on the horizon, and I'm going to share those with you. I'm going to share those with you now. So a couple of them I'm going to talk to you about in a bit more detail. But what these are looking to deal with is maybe looking at a more family-friendly approach to work, which has been one of the government's main objectives almost, is to make sure people are not inadvertently disadvantaged because of what they do or where they work or the hours they work. So some of this, the first is the change to the right to request flexible working. I'm going to talk about that next. From a family-friendly perspective, there's going to be the introduction of carers leave. So that will look to give carers the ability to step out and deal with someone that they might be looking after without having to, be in a situation where, because there is no more formal legislation around it, sometimes carers aren't able to do that. So that supports that. And the same with neonatal care leave and pay. Unsurprisingly, I think, again, for maybe some of our colleagues in the HR community here, there's starting to be some focus back into looking at protection for pregnancy and maternity leave during redundancy. So another very difficult area to sometimes navigate if you've got employees on maternity leave and the company's thinking about redundancy pay. This is a tough area to navigate, but it can sometimes, one could argue, leave the employee at a disadvantage, not because they were pregnant or hopefully been on maternity leave, because that in itself will be discriminatory, but because having been through that, the ability to dismiss them is maybe too straightforward, I think, and arguably slightly unfair if someone's just come back from maternity leave and faced with redundancy. So I believe the protection is looking to close that loophole. The introduction of liability for third-party harassment. This is coming through more whereby there's a sense that because people are working more remotely, maybe we aren't just working in offices as we were, that people are dealing with more third-party providers, and unfortunately there are some scary examples of where harassment has taken place in that relationship. So the introduction of third-party harassment rules will be coming. And finally, good news, I'm sure, for those involved, that rules to ensure that tips are passed to workers in full will be enacted. So that, as I say, is good news for those. I've picked out a couple that I thought would be useful for you, that maybe are more practically, from what we see with our clients, are more practically impactful. So what is going to change is the ability to request flexible working from day one. So there is a waiting period at the moment for employees to go through before they're able to come to their employer and say that they'd like to formally request their working arrangements become different, essentially, to what they are doing at the moment. So to be able to work flexibly, that could be to reduce their days, reduce their hours, or any one of those permutations. And as you may know, the employee then has to provide some evidence around why they want to do that and some rationale. And then we as employers are obliged to consider that within a framework and to respond accordingly. It does, I guess, even things out a bit. So employees will have the right to ask for flexible working to be considered, and employers will have 2 months to respond. So there is some time in there to look at what the operational impact might be and the other important factors that should lead you to make your decision. Personally, I wouldn't recommend that you will want to take 2 months, because it can create a little bit of unsettlement if an employee feels that they're not quite sure where they are with their working arrangements. So I wouldn't necessarily leave it that long. Although at the moment it is a 3-month period, I believe, that you have the right to consider the request. In the current rules, there is some onus, as I've just mentioned, on employees having to explain how they feel flexible working will work, and it can, from experience, be a little bit awkward for employees to try and find what they believe are reasons why it works beyond actually I have caring responsibilities, or my childcare, for example, is an issue. I need help with that, and employees are often asked to come up with how operationally these things might be covered, which can be a bit hard for some people. So that's going to be removed. The other bill that I've pulled out that has, I guess, had quite a lot of press coverage is the revocation, and reform bill. And this is all sitting around some of the noise you might be seeing in the press around how EU law applies to UK law. And you'll know that in simple terms, EU law is extremely intertwined with UK law for super obvious reasons. And from the 31st of December, that will no longer be the case. And it does then give the government the opportunity to change the EU laws. There's various speculation about what that might look like. I've listed here, for example, that some speculation suggests that the change will come first in the agency worker and working time regulations, and then in the 2P regulations. But really and truly, it's hard to say. And trying to unpick EU law out of UK law is a very difficult process, because, for example, some legislation will connect in with others. So the working time regulations is as much was part of created by UK legislation as it is by the EU. So finding what the two differences are is going to be a challenge, not a job that I would want. But nonetheless, just be aware that this is potentially going to be coming, and I'm sure once the government turns its mind to it, that we'll know what their position will be. The final one I wanted to pick out was the minimum service levels bill, and this again has received a lot of press attention. This is the bill whereby the Prime Minister came out and talked about wanting to establish, if you like, a minimum service standard for various public services. And most notably at the time, that was focused in the areas of healthcare, where the nurses were on strike, and transportation, where the train drivers were on strike, and initially seen as a response to the disruption, arguably, that people may have felt as a result of those two pieces of strike action. It will be, I think it will be a slow burn to pass this, potentially, because understandably the unions are quite against this concept, because it flies in the face, one could argue, of the right to strike. So, but what we know from some of the detail, for example, is that employers would need to work with unions to specify what is the minimum level that say the transportation system needs to be able to operate. So I think there's quite a lot of ground to cover here, potentially, before this actually becomes something that in reality we gain experience from. But let's see. And the other point that's maybe sort of slightly contentious is that, from an employee's perspective, what I understand is that during strikes, if workers are asked to work and choose then not to work, then they won't be protected from making an unfair dismissal claim, because essentially what this minimum service level bill will do is mandate them to work. So a complicated landscape to navigate, I would suggest. Okay, so again, do please share. I'm just going to check the chat to see if we've got any questions coming through. I don't think we have quite got any questions as yet, but yes, do please share some questions that you might have. So just as we move towards the sort of end of this, I thought it would be useful. We are often asked what's happening, not just in terms of changes to employment law, but what are the employment law cases that are going through the system that might affect us, is a question that we often get asked. And so to respond to that, I thought you might find it useful to hear some of those. So I'm not going to do a huge case review or go into this in too much detail. I'm just going to give you, if you like, the headlines and most importantly, what the learnings for you might be. So the first is the Smith v Pimlico Plumbers, Pimlico Plumbers case. So Pimlico Plumbers, a very prominent local employer, actually, one that's actually not too far from us, very successful business, the model of which is that they have plumbers and other, technical people that are essentially working for them as contractors. And yet, actually, whilst that was the model, what happened was that in the first instance, Smith, who was part of the Pimlico Plumber team, took them to court and basically was awarded the decision that he was an employee and not a worker. So the first big piece that came out of this was that you have to make sure, in terms of employment status, which in itself is quite a complicated area, that just because we call someone a contractor, that they are working as a contractor. And there are quite specific rules around that in terms of not being totally, I guess, in summary, beholden to the employer, having the right to be substituted, use of equipment and other things that will essentially demonstrate that there is no employment relationship between them. In this instance, what the tribunal found was that Smith was, because of that, because he was very involved with them, worked for them a lot, in kind of simple terms, that he was therefore an employee. What that did then was trigger a claim for backdated holiday pay. And this was, again, a decision that was upheld because it was found that because he was an employee and he hadn't taken holiday or been paid holiday, that he was entitled to backdated holiday pay. So the watch out here is to make sure, first of all, that you're correctly classifying people. So if you have contractors that are called contractors but might be in the office with you Monday to Friday, 9 to 5, using your equipment in your team meetings, going to your staff Christmas dues, then they're not going to be seen as contractors at tribunal. So to have a look at that, and then secondly, have a look at how you're treating holiday pay, because where people aren't being paid holiday, they do have the right then to take a claim for backdated holiday pay, and that could be quite substantial. The second is Finn v the British Bung Manufacturing Company and Mr. King. And this was an interesting case to follow. This essentially was about inappropriate behaviour at work. And he took the employer to tribunal because he claimed that he was discriminated against because of what he was referred to in quite an expletive conversation. And just reading from my note here, that the tribunal found that there was discrimination because his sex and the fact that he was bald, just to be clear, and this is on public record, was seen to have been discriminatory against him on the basis of sex, and so a claim of unlawful harassment was upheld. Now, these are often stories that are told around the dinner table or in the pub and things that, people are aghast. I suppose the reason for me pulling it out here is to make sure that we remind employees that there is a particular minimum standard of conduct at work, but that actually beyond that, even the consequence of using very derogatory terms or very directed terms could lead us to be in tribunal for claims, as this has been, for discrimination or harassment. The other quite contentious case, if I may say, was this for starter v CGD Europe and others. And this received quite a bit of press attention at the time. This case, some of you may be aware of it, was that an individual posted statements on her own gender critical beliefs. So she made claim, and forgive me if this is not wholly accurate, but she made claims, as I understand it, that that rested in her view of what gender identity should, in her mind, should be about. She was dismissed. In actual fact, she wasn't dismissed. Her contract wasn't renewed. She was working for CGD Europe, and she took, she took a claim for harassment. And actually, what was found was that in her favour, she was entitled to share her own gender critical beliefs in the workplace under the Equality Act. So the Equality Act essentially was deemed to be saying that she herself was protected for sharing her own belief about gender. But what it does highlight is that even if an individual has a belief, and even if that belief is still considered to be protected, if you like, we must remind staff that offensive or derogatory statements are not acceptable, and that's manifesting beliefs in an unacceptable manner in itself can result in action. So a very difficult and sensitive case, but interesting, I think, for the onlookers, how that was then interpreted at tribunal. One that we see, unfortunately, more and more often, R.V. Andrews. So this essentially was where an individual was a serial fraudulent CV provider. He had gone through a series of roles, and unfortunately was rumbled, and it was found that he was fraudulently basically claiming, I think, for things that he shouldn't have been, and that was considered to be a criminal offence, because he had essentially moved into defrauding companies, which, as you know, is criminal. So a call out there from me to make sure you're doing the right background checks and other reference checking procedures that you might have, because this is definitely on the rise. This whole idea of fraudulent CVs, unfortunately, particularly in today's environment, I think is sadly something that people are feeling they need to use. So yeah, keep your eyes open for that. And finally, something we unfortunately do tend to deal with quite regularly is redundancy. And Morgaine v Bradford Teaching Hospital was a case whereby essentially Morgaine, who was a nurse, because her contract terminated earlier than a colleague that was put in a selection pool, she was basically made redundant. The finding in this case being that proper process should be followed, proper redundancy selection process, and as you'll know, all of the things that sit around that, because it's unfair just to pick one person out in a pool and determine that unilaterally they are the person that should be made redundant. So a shout out here to make sure that if you are working through redundancy processes, that you are making sure that you're following them properly and not just assuming, if you like, that just because someone is last in, it can be first out, although even that has some grey areas around it. But do talk to us if you want help around how to deal with redundancy processes. So some quite interesting employment law cases, always, as I said, to summarise, cases we like to draw to the attention of our clients, because it, I guess, independently shows that whilst we spend a lot of time helping clients stay away from these areas, and I'm pleased to say none of my clients are certainly having to go through some of the traumas you're seeing here, nonetheless, sometimes even in the busyness of what's happened, we suddenly find ourselves not in the right place, and this can be the consequence of that. So, okay, so what does all of that mean? So I've talked to you in summary about this year's employment law changes in April. I've talked to you about the risks potentially from some of the cases that we've seen. So what do you have to do next? And I would just leave you with this little checklist. What we would want you to do now is think about what are the risk areas that I might have uncovered here for you in this webinar, and how are you going to plug them be that making sure the minimum wage rate is increased for your employees, or that you're using the right statutory redundancy weekly pay calculation. Go back, have a look over your documentation. If there are any of your company documents that include these rates, obviously make sure they're up to date. And I would always suggest that you then take the opportunity to make sure your own management team are aware that these changes have taken place, so that if something comes up, everybody is, got their eyes open to potential mistakes. And then I know we have some HR colleagues with us, which is great, but for those that aren't, what hopefully you're also seeing here, that it's really, really important to have the right HR advice in place, because sometimes, and actually most of the time, to be frank, where some of my clients maybe are undertaking actions that are not quite right, it's often not done in malice or willfully wanting to sidestep the law. Having the right HR advice in place means that people like us can help stop that and push people gently back onto the right track. So just in closing, a little bit about the HR department. We are here to help. We are essentially an outsourced HR provider. So we do everything that an in-house HR team would do, but we do that from a distance. So as you can see here, we do everything from providing a monthly retained HR support service, where we are open and available via phone and email, and often visibly, because we like to work with, we like to work face-to-face with our clients and help deal with employee relations issues, documentation requirements, and anything that's HR related. And that's underwritten by a great employment tribunal insurance. Beyond that, we do pay-as-you-go work. So very often we'll work alongside other HR professionals. It might be that we're doing grievances, appeals, or other project work that HR teams internally are just not quite getting to. We have a great management training program that we can provide. That's going to be coming out shortly, so you'll hear more from me about that. And we can help with benefits and other things. So we provide all of the services, just to reiterate. And I'm very pleased to say that that's been endorsed, much to my delight, if you like, by our clients, who have awarded us 100% across the board for the services that we provide. We do love these events. I'm sure you've seen us on LinkedIn and Eventbrite and the other platforms. We've got a great webinar coming up in a month or so's time around how to attract and retain great talent. We're then going to be looking at health and well-being, and these topics are deliberately there because they are the things that people are talking to us about most of the time, and that we're talking to our clients about most of the time. And then beyond that, we also have drop-in surgeries every Tuesday, where you're welcome to come and talk to me virtually. If you've got questions or things you want to kick around, then as you can probably tell by now, I love to chat. So you're very welcome, and they are free and confidential. Just before I go to questions then, just to say in finishing, we are also on all of the on all the social media platforms, LinkedIn, Twitter, Facebook, and by phone and by email. So do please not hesitate to reach out to us if you think that we can help you. So thank you for coming. It's been a real pleasure to talk to you. I hope that you found that useful. As I said, I'm happy to stay now for questions. Otherwise, we will send you a copy of these slides as a follow-up to this session. And please, by no means, hesitate to ring me or email me if you want any follow-up advice or clarification. So I'm just going to go to the chat function. Great session. Thank you. Thank you, Pamela. That's very kind. If there are no more questions, you are very welcome to drop off, by the way. Thank you, Tara. Great to have you. Thanks, Leanne. Thanks, Effie. Nice to see you. Great. Okay. Well, thank you, everybody. I don't think we have any more questions. So thank you once again, and I will close the webinar there. Thank you.